During the course of your lawsuit, we have an opportunity to question the doctor whom you have sued in your medical malpractice case. If the defense lawyer refuses to produce their doctor over and over again, are there any repercussions for the defense for failing to produce the doctor for questioning? You want to know the answer? Come join me for a moment as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. It's a gorgeous day today here in Great Neck, and I want to share this terrific information with you. All right, so let's say you sued your doctor for medical malpractice. You believe that he was careless, causing you significant harm and injury. The doctor whom you have sued now, at some point during the course of your lawsuit, will have to appear for what's known as a deposition. This is a pre-trial question and answer session that's given under oath in his attorney's office. Now, there's no judge there, there's no jury there, but there is a court reporter that's going to be there when I have a chance to question him. And the court reporter is going to record all of the questions that I ask and all of the answers that the doctor gives. And his answers represent his sworn testimony that's given before trial. And you should know it carries the same exact weight as if he is testifying at the time of trial. So now, during the course of your lawsuit, we have to schedule this doctor's question and answer session. And we schedule it one time, and then it gets put off. We schedule it a second time, and the defense is not ready to go forward. And a third time, and a fourth time. And this is getting ridiculous. So now we ask the court to intervene. We say, Judge, this is ridiculous. They are required to appear for this questioning. They have failed to do so multiple times now. They haven't given us a decent excuse or a decent reason why. We now want you to take action against the defense for holding up and delaying our particular case. We cannot go forward with this particular case until we get to question this particular doctor. We want you to take action. And the court turns to us and says, well, what kind of action do you want, counselor? Judge, we want you to dismiss their answer to this lawsuit. That is the most extreme request that I can make in this instance. Now, what does that mean? You see, when we start a lawsuit, we serve a set of papers known as a complaint, a summons and a complaint. And that's a listing of the allegations that we are making against the doctor whom you have sued. In response, the defense attorney will prepare a set of documents answering those allegations. And that has a fancy legal term known as an answer. How do you like that one? Okay, so now what does that mean? It means they are now answering the allegations, and they are typically going to deny all of your allegations. They're going to say, listen, we did nothing wrong, number one. Number two, if we did something wrong, whatever we did didn't cause or contribute to your injuries. Number three, they'll say, listen, if we did something wrong, so did you, Mr. Patient. Then they'll say, you know what? If I did something wrong and it caused you harm, whatever injuries you suffered really are not as bad as you claim them to be. Those are the typical answers or defenses that we see in these medical malpractice lawsuits. What happens now is that the case proceeds forward. But the defense has now answered the allegations. If I am now asking the judge to take action and dismiss the answer to the allegations, what does that mean? It means that it's as if they have never answered the allegations to begin with, and we get an automatic win. It's basically getting a default. Now, what's a default? Here's a great example. Imagine the Mets are playing the Yankees, and the Mets just don't show up. The Yankees get an automatic win. It's an automatic default. Okay? They never actually played that particular game, but the Yankees win because the Mets simply didn't show up. If the judge agrees with us and strikes the defendant's answer, what happens? It's as if we get an automatic win, and now we win on default. Now, does that mean we win everything? The answer is no. It means we've won the first part of your trial, that we no longer have to prove liability. We no longer have to prove causation. Instead, the only thing left to determine is how much money you are to receive as a result of all the harms and losses and damages incurred by your careless doctor. That's known as having a trial on damages. How likely is this request to be granted if the defense refuses to produce their witness over and over and over again? The answer is, it depends. It depends on the judge's temperament. It depends on what the judge has told the defense attorney. It depends on what excuse the defense has given the judge for why they've been unable to produce their doctor for testimony. So it's not as simple as saying, okay, if you don't show up for the third time, now we're automatically going to dismiss your answer and the plaintiff gets an automatic default. No, it doesn't work that way. The judge is going to listen to the excuse, the judge is going to consider it, and then determine what action, if any, is warranted against the defense for failing to timely produce their doctor for deposition. Why do I share this with you? I share this with you just to give you an insight and an understanding into what really goes on in these medical malpractice cases, these accident cases, and these wrongful death cases here in New York. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.